So for those of you who just joined us, my name is Nancy Worley, and I am the Interim General Manager for KPBS. Thank you for being here today. At KPBS, we strive to bring the community together to educate and to enlighten. We do that through our thoughtful journalism, our fair and trustworthy news, and our engaging programming, which we provide across all platforms, TV, radio, and digital. We also do it through our community outreach events, like our upcoming GI Film Festival and our One Book, One San Diego. And through events like this, our Estate Planning 101, where we want to engage with you, the community, about important topics like estate and legacy planning and let you hear from experts like our speakers today. We typically hold this event in person at the station, and I look forward to a day soon where we can once again be together and be safe and have those great experiences and be able to say thank you for your support and share in these experiences. So until then, thank you for joining us here virtually today. I do want to take a moment to thank our presenters, Christine Chacon and Rick Brooks. Wave, hi. Both of whom sit on our Planned Giving Advisory Committee and whom, along with others on the committee, advise KPBS and our members on planned giving tools and tips for including philanthropy in your estate planning. I know everyone on the committee is always happy to help answer questions, and we can't thank them enough for what they do to help us at KPBS. Estate planning is an important tool we should all think about and use. It's never too early, never too late to get started, and it brings peace of mind to you and your loved ones. Also, estate planning gives us a chance to think about what we wish to accomplish even after we are gone. By including philanthropy in your estate planning, you can make an impact and continue your legacy of good work. As you will hear, there might be even some tax benefits available to you while you're still alive. I know personally the impact planned giving and estate gifts have on nonprofits such as ours. KPBS is so grateful for the support that we receive through planned gifts and bequests. This support has really allowed the station to continue to thrive and grow, and has allowed our donors to continue to support the programs they care deeply about and supported through their lifetime. Whether or not you decide to include KPBS in your estate planning, I want to thank you for joining us today and encourage you to think about what you want to accomplish and how philanthropy and planned gifts might help you with that goal. So thank you again for being here. It's now my pleasure to introduce our event host and KPBS Major Gifts Director, Jared Blakely. Jared?
Thanks, Nancy. But before we get started, we do have some housekeeping reminders. This is a Zoom webinar, so your cameras and mics will be turned off. We can't see you, but you can hopefully see all of us. This webinar features closed captions, and so if you perhaps are hard of hearing or prefer to read along, you can enable that feature by just selecting the button at the bottom of your Zoom window. And I also want to let you know to be aware that this webinar is being recorded. You guys will all have access to a copy when we send that out in a post-event email, but just wanted everyone to be aware. Throughout our time, if you have questions, please make use of the Q&A box, which you can see at the bottom of your Zoom window. If you have technical difficulties, you can raise your hand or send a message in the chat box. One of our event staff will do their best to assist you remotely. It is now my pleasure to introduce our first speaker, Christine Chacon. Christine is an attorney at Best & Krieger and practices law in the area of probate and trust administration, estate planning, entity formation, business consulting, and business succession planning. We are so happy to have Christine here today. We will take some time after her presentation to answer some questions. Please put them in the Q&A box throughout the presentation, and we'll do our best to get to as many as possible. We also have scheduled some time at the end of both presentations for questions, and so if we weren't able to get to yours right away, hopefully we can get it on the back end. And with that, I just want to welcome Christine.
All right, thank you so much. Hello, everyone, and thank you for being here today. And we can go right on to our next slide. And we can just go right on to our next one. Jared already provided a nice introduction. I have been doing this for 10 years as a trust and estate attorney locally here in San Diego. So I hope I have some good information to share with you today. We can go on to our next slide. So because our poll just informed us, a lot of us are at the beginning of our estate planning journey. This is just an overview of what to expect when you put your estate plan in place. So we use the term estate plan, but what does that really mean? While everyone's plan will vary, we usually put together a trust, a will, a power of attorney, and an advanced healthcare directive. If you own property, we also prepare deeds transferring your property into your trust. We will go more in depth into the trust and the advanced healthcare directive today. So I want to give you a little background on why you would also need a will or a power of attorney. Your will typically serves as a backup document to your trust. Your trust is going to end up owning many of your assets. So the will includes a clause that says, if anything remains in my own name at the time of my death, please place it in my trust, pour it to my trust. That's how we still direct your assets to your intended trust beneficiaries. Your power of attorney is put in place for the event of incapacity. If you are ever incapacitated, while your trust would handle trust matters for you, there are numerous other things that end up needing to be taken care of during a time of incapacity. And it's good to note that most estate plans will define incapacity as determined with the opinion of 2 licensed physicians. So we're not just having someone say, hey, I think John Smith isn't doing well today. We have our doctors determine that. But the power of attorney would allow your agent to sign tax returns for you, pay your bills, check a PO box, all those things that only you are legally able to do. And we can go on to our next slide. So why establish an estate plan? Why do we need one? And what are the benefits of it? Of course, I did just touch on incapacity planning. Your trust can plan for what occurs in more depth in the event of incapacity. Are you to stay in your home? Do you have a business that needs to be managed for you? Are there certain gifts that you have going out to children that should continue in the event you aren't managing your own affairs? Really important is that your estate plan allows you to choose your own beneficiaries and choose how they receive your assets. If you don't have one in place and it defaults by what we call intestate succession, it goes to essentially your closest living blood relatives as determined by state law, whether that be a spouse or children, a parent, a sibling. And particularly in California, probate avoidance is really important. If your assets are held in a trust, they do not have to go through our probate court at the time of death. I am also a probate attorney, so I can provide more information on the probate process. It's very expensive. That's why I've listed out the fees there. Those are set by our statute. They're set in our California probate code. The executor who handles the probate for your estate collects those fees based on the fair market value of your estate at the time of death. It is not adjusted for a mortgage or any liabilities. Additionally, the attorney who typically handles the process for the executor collects that same fee. In San Diego, it's just good to know we have 3 probate judges for our entire county. So when I file a case, my cases are usually put out about 3 months before I can even get a hearing in front of the judge. So in turn, we anticipate about a year-long process at the least when we're settling someone's estate through court. So the takeaway there is that when you have your living trust in place, it keeps your matters private, just between your trustee and your beneficiaries, and it keeps us out of this court process. And we can go on to our next slide. So I do like to review some measures to help you decide whether or not you need a trust. You know, sometimes it is appropriate to have a simple will in place or to pass certain assets by a beneficiary designation. These are 3 helpful measuring points. If you own real property, if you own your home or a commercial property, any type of real property in California, particularly valued over $50,000 fair market value, that should be in a trust. Otherwise, it will go through our probate court when the surviving owners are deceased. If you don't have real property, or if you do and you also have cash accounts, when cash, investments, stocks, bonds total $166,250 or more, for your successors to access those accounts, they would have to go through a probate process, again, unless they're held in a trust. So I typically advise that if your cash assets are around $100,000 or more, let's absolutely have them in a trust. Certain assets will have beneficiaries designated. We'll talk about that a little more, but it's very important also to make sure that you have an individual or a charity named on an account so that those don't default to our probate process as well. And then in San Diego, we have a lot of small business owners. Your trust allows you to state how your business is run when you can't run it. Should it be sold? Is there a child who should take it over? Do you have a key employee who you'd like to offer a right of first refusal? Are there certain business assets that need to go on to another business owner you know? All of that can be detailed within your trust. And we can go on to our next slide. So for those of you establishing a trust now or reviewing your existing trust, these are some key points to go through. Who to name as your trustee? Your trustee is an integral part to your trust. It is the person who will act in a fiduciary capacity to marshal your assets and manage your assets for the benefit of those people or charities who you name as your beneficiary. So in other words, they are stepping in your shoes, handling your accounts, paying your bills, selling property, liquidating assets. It's a very important role. It can be a friend, a family member, your child. It could be your CPA if they're willing to serve. Many people prefer it's a third party. We have some excellent certified licensed professional fiduciaries locally who will serve in that role. And some bank departments are also appropriate to serve as a corporate trustee, again, depending on your own circumstances. Also, it's great to establish and review who the beneficiaries of your trust are, who receives your assets at the time of your death, and how do they receive your assets. You can go beyond saying that everything goes to them outright. You may wish to keep some controls or some measures in place. For example, by establishing a certain age for a child to receive an asset. There may be some special needs planning needed, or perhaps you would like to provide for someone's health and education only, and funds should not be accessed for any other purpose. You can put all those measures in place to meet your intent. And then a really, really important part of establishing the estate plan or reviewing your trust is making sure your assets are actually funded to the trust. This means that for most assets, not all, your trust will be placed as the owner. So your trust becomes the name on the deed to your property or on the title to your investment account. That is how you actually transfer them into the trust and make sure the terms of the trust apply to it. So for those of you with an existing estate plan, I encourage a review about every 5 years with your attorney or with your financial advisor. Go through your asset list and just say, hey, do I have my accounts properly titled or the appropriate beneficiaries named? And we can go on to our next slide. I wanted to take some time specifically on advanced healthcare directives right now, just due to the coronavirus pandemic. whether or not you put a complete plan in place, you can absolutely put in place a standalone advanced healthcare directive. I say it's crucial for every adult 18 and over. If you have, children in college, get one in place for them. It allows you to name an individual to make healthcare decisions and speak on your behalf when you can't make your own. And that has, of course, become really apparent to us in light of current events. And if you really think of how this would work, it means that individual gets to state, yes, I authorize a certain treatment plan, or yes, I would like this operation to occur. They have HIPAA authorization to be able to discuss your private healthcare records with your physicians. And of course, it allows you to select the choice to prolong life or not to prolong life if you are in a permanent vegetative state. Your family may not know your wishes otherwise as to what should occur if you were on life support. So it is really, really helpful to convey that wish in this document. Other specific directives can be written in as well, such as organ donation preferences, preferences as to cremation or burial, and preferences to receive pain relief. And we can go on to our next slide. So this is a list of some current relevant laws that may affect your estate planning. It used to be pretty common to name a trust as a beneficiary on an IRA or a 401k. And that's now only recommended in certain case-by-case estate plans. So that's good to review with your own advisor or attorney. They can no longer be stretched over the lifetime of your beneficiary. There's now a 10-year limitation. So in the event that you do have a trust name on your 401ks or IRAs, please look at that right now due to the changes in the Secure Act that went into effect actually in 2020. Prop 19 is probably the hottest topic right now because it goes into effect on February 16th. On February 16th, there will no longer be a unlimited parent-child exclusion for the transfer of a primary residence. So under current law, you can transfer your primary residence at any value to a child, and there are no limitations on that child's use of the residence. You can also transfer a secondary property, such as a commercial property or a vacation property, to a child, and they would receive an exclusion from property tax reassessment up to $1 million. Now, only a primary residence can be transferred to a child who also uses it as their primary residence, and there is a cap on the value. Finally, our federal estate tax exemption has increased to $11.7 million per person. The estate tax rate is 40%. So those estates at that value may wish to consider some advanced planning. Particularly, we are anticipating that it may decrease to $3.5 million or $5 million per person this year under our new administration. And we can go to our last slide. So in the event that you have or may have a taxable estate or wish to do any charitable giving or planning, there are ways through irrevocable trust and charitable giving to reduce the amount of your estate that would be taxable at the time of your death. That might be by naming your trust as a beneficiary, by naming a charity as the beneficiary, by naming an organization as the beneficiary of an irrevocable trust. There are many types you can put in place, which is something that we or Jared through our plan giving department can talk to you more about later. But it allows you to make that gift, reduce your taxable estate, and depending what type you put in place, perhaps receive an income stream or still receive a benefit from the property as well. And of course, annual gifting right now is at $15,000 per person. And if you do name a charity or an organization as a beneficiary, I always encourage considering the purposes of the gift. Is it to be used for general purposes or to be given to a specific fund? The more instruction you put in place, the better. And that's why I really encourage you to contact plan giving departments, such as ours at KPBS, to help you structure that properly, because many of these methods are irrevocable. So let's get it set up correctly up front. And we can go on to our next slide. So that will provide you with my contact information. I'm happy to discuss estate planning matters further with any of you personally after this presentation. And thank you so much for your time.
Thanks, Chris. Thanks, Christine. We're just going to take a couple questions, and then we will move on to Rick, and then we'll bring Christine back at the end to answer some other questions that we don't get to. But first question I'd like to ask is, someone was wondering if every time you move states, if you should your trust should be redone to maybe meet standards of any new location that you're now calling home.
That's a great question. So your trust can hold property from anywhere within the US, but I do encourage reviewing it with an attorney in your state, because each state has different probate laws. Advanced healthcare directives are particular to each state, as are the power of attorneys. So yes, at least have it reviewed by a local attorney.
And then one last question is around incapacity. I think this is pertaining to the health directive. Is there an alternative to having two physicians determine incapacity? Often a person may be in a healthcare facility or hospital and not have two physicians who know them and are willing to state capacity.
Absolutely, that's an excellent question. And that's something that we can discuss during the planning phase. It could be an attending physician, meaning someone at the facility where you are at, and they would be contacted probably by the individual helping arrange this for you. It could be a physician and maybe a panel of your family members. It can absolutely be structured in other ways. I would state, however, that two physicians is probably the most common. It can also be set to be effective immediately, which is important to note. So if you said, well, I already have a trustee or a child that I would like to help me with these matters, they can be written in to act as your trustee now, as opposed to being effective on incapacity.
Wonderful, thank you. So we're going to save the rest of the questions until the end. There's a lot of good ones that are coming through, so I encourage you to keep entering those. Some of the questions that have come through will be addressed in Rick's presentation, so hopefully we'll cover some of them there. But afterwards, we have left time to answer additional questions. So I thank you, Christine, again, and we'll call you back here in a little bit. But with that, I want to introduce Rick Brooks. Rick is a chartered financial analyst charter holder and a certified financial planner with more than 20 years of experience in financial services with Blankinship and Foster. And for the last 15 years, Rick has specialized in portfolio management, financial, tax, and estate planning issues for clients from all walks of life. With that, I'll turn it over to Rick.
Thank you, Jared. Appreciate it. That's an interesting picture. That same guy? Anyway, I'm here to talk, the title of is plant the seed. Well, this financial planning is sort of about nurturing the seeds and helping them grow and getting the most out of, your yield, to keep up with the farm metaphor as you can. So let's click the slides. Like I said, I've been doing this for about 20 years. I'm a financial guy. Christine is an estate specialist. I read a lot of estate plans. I read a lot of powers of attorney. So we help our clients make sure that what they're telling Christine is what's in the documents and that everything is good. And we also talk again about integrating the other aspects of finance with the management of your affairs. So next slide, please. I'm not an accountant. I'm not a CPA. I'm not an attorney. I'll have some examples in here. They're general in nature, but if you're going to go through some of these strategies, really should talk it over with your advisory team. Next slide, please. Okay, so an important point about estate planning, Christine sort of alluded to this. It's complicated and the rules are changing constantly. Congress loves to rewrite the rules. They've done it twice in the last 3 years. 2017 was a big one. 2019 was a huge one, actually. It's kind of overshadowed by the whole COVID thing, but it was a pretty big change to the code. The tax benefits can change as well. So you want to keep on top of that. But the important thing, we're talking here particularly about giving, charitable giving. The tax benefits will help. They'll make that easier, but you're still giving money away. Don't give money away for the tax benefit. You give money away for the charitable intent. Next slide, please. Okay, love this quote. As you grow older, you will discover that you have two hands, one for helping yourself, the other for helping others. And this is about using both of those hands together while you're helping charities, KPBS, for example, helping yourself as well. Next slide, please. All right, so Christine talked about this a little bit. The Tax Cuts and Jobs Act of 2017 did a lot of things, but it did two things that were really affected philanthropy and charitable gifting. It doubled the standard deduction, and it capped the deduction of state and local taxes at $10,000 and eliminated many miscellaneous deductions like business lunches and things like that. Those of us in California still have not forgiven Congress for that SALT, the $10,000 cap. Next slide, please. Okay, but that cap had a very important impact on philanthropy and charitable giving because it meant that a lot of charitable gifts were no longer deductible. People were getting the standard deduction anyway. And in fact, the year after the TCJA passed, we saw about a 1% reduction in charitable giving and philanthropy, in large part because people couldn't write it off on their tax returns anymore. Next slide, please. So let's talk about giving efficiently. Next slide. When I talk about bunching gifts, it's sort of like bulk, right? I mean, we buy in bulk to save money because, 20 rolls of toilet paper, if you can find them, are cheaper than one, right? You only go to the store one time instead of 20 times. So next slide, please. So bunching is a strategy that combines multiple gifts into a single year. So if you're going to give, say, 5, 10 grand a year for the next 5 years, well, you put it all in 1 year. And by doing that, you can recover some of the benefit of being able to deduct these things from your taxes and still use the standard deduction in the off years. Next slide. So there are a bunch of different ways to do it. You can, give 25 grand and then, not donate anything over the next few years, or you can use something called a donor advised fund like the San Diego Foundation or the Jewish Community Foundation or Schwab Charitable. There are a lot of different ways to do this. You can give larger gifts to the donor advised fund and then parse those gifts out to the individual charities over the years. Next slide, please. So here's a real life example. This is an analysis that we did for a client of mine. You'll see there's two sections here, the top and the bottom. I took the client's 2018 tax return. He had $9,000 in state and local taxes. He gave 10 grand to charity, and he took the standard deduction. None of that was deductible. I planned it out over the next 4 years. So if you continue the way you're going, you're going to give 10 grand a year. You're going to get the standard deduction. Great, thank you for giving to charity, but it won't help you because you're still going to get the standard deduction. So look at the bottom half here. What we did is we had him give $20,000 in 2019. He gave nothing last year. He gave another $20,000. He'll do that this year in 2020. And by doing that, he got to itemize his deductions in the off years, 2019 and 2021, and then took the standard deductions in 2020 and 2022. Now, what this did is it increased his deductions over these years by $10,000. That's not chump change. At a 30% tax rate, that's 3 grand over 4 years. That adds up. Again, it's about efficiency. Same gifts to charity. He's still giving 10 grand a year to charity, but he's lumping it to make it more efficient. Next slide, please. And let's go on. I already kind of hit on this. It's a $10,000 benefit. Next slide. Okay. So speaking of efficiency, let's say you wanted to give a gift to charity. You could either write a check, you could sell some stock, or you could give the stock away. If you have to sell stock to give cash to charity, you're going to pay tax on any gains in those stocks. On the other hand, most charities can accept the gifts, so why not just give the stock to the charity? Next slide, please. So here, let's use an example. Let's say you were one of those fortunate few who bought Qualcomm in 1998. You still own some of it. Let's say you bought 100 shares, cost you $5 grand in 1998. Today, those 100 shares are worth about $260,000. First of all, congratulations. Second of all, that's all capital gains. If you sell that, most of that is going, to be taxed. So next slide, please. So between the state and the feds, sorry about the formatting there. So between the state and the feds, you would have to sell $32,000 of stock to pay $7,000 of taxes to write a $25,000 gift check to KPBS. Your gift would cost you $7,000. Next slide. On the other hand, you could just give shares to KPBS. They don't pay taxes when they sell the stock. They get $25,000. The IRS gets nothing. 200 shares, sell them, pay taxes, or just give away 150 shares. Again, the same gift to KPBS, $25,000, but much more efficient way to do it. Next slide, please. Already said all this, so let's go to the next one. Okay, IRAs. We talked a little bit about IRAs already. Christine mentioned a few things. Okay, there's a tool that we've been using for a few years called a qualified charitable distribution. You can do it once you reach age 70 and a half. Distributions from your IRA go directly to the qualifying charity. You can do a maximum of $100,000 per year, any amount up to that. These amounts count towards your required minimum distribution. So after you hit 72 now, you have to take money out of your IRAs, your 401ks, your 403bs, et cetera. Well, if the money is in an IRA, you can send it directly to the charity. When you do that, it's not reported as income on your tax return, and it is allowed even if you're taking the standard deduction. Next slide, please. So one important caveat, it's got to be a qualifying charity. You cannot send a qualified charitable distribution to a donor advised fund like the San Diego Foundation or a fund that you might have at the Jewish Community Foundation. It has to be a 501c3 eligible charity, which means it is a tax exempt in pursuit of philanthropic, nonprofit, or civic activities, like KPBS, for example. Next slide. Okay, so here's how this works. Normal gift to charity, you withdraw money from your IRA, you put it in your bank, you write a check, you send the check to charity, you get the income from the IRA on your tax return, and you put the gift as a deduction. The amount of the IRA distribution is included in your gross income, and you get a deduction for the contribution. With a QCD, though, the money comes straight out of your IRA, straight to charity. You never touch it. Do not pass go. Do not collect $200. Don't put it on your tax return. Now, you can't deduct the donation, but you don't get the income either. And I'll show you in a second why this is better. Next slide, please. Okay, so let's take an example here. Let's assume we got a married couple over 72 filing jointly. They want to give $10,000 to KPBS. Their property tax is 10 grand and they have no other charitable gifts planned. Next. Okay, on the left, we have a donation to KPBS without the QCD. They have $230,000 of other income. They get a $25,000 IRA distribution. They put it in the bank. They pay their state taxes. They pay their property taxes. Notice the itemized deductions. Their state taxes are capped at 10 grand. Their itemized deductions are 20,000. They take the standard deduction in total. Second line from the bottom, they pay 58,000 in taxes. On the right side, we do it with a QCD instead. So now the distribution from the IRA to their bank account is only 15,000, which means their state taxes are lower. They still get the standard deduction of 27,800, but look at their adjusted gross income. It's lower by $10,000, which means their state and federal taxes are lower. And KPBS still gets the same $10,000. Next slide, please. There's a tax savings of $3,000. Again, the same gift went to KPBS, the same income came to them, but their tax bill was lower. Why? Because we used that qualified charitable distribution for a more efficient way to do it. Next slide, please. Remember those round cook commercials? But wait, there's more. Higher income can lead to higher Medicare premiums. So in this example, I kind of picked that number for a reason. That higher income bumped them into the next Medicare premium gate. So in addition to paying more taxes, their Medicare premiums go up. So by using the QCD instead, this family could save a total of about $4,500 in 1 year. Next slide, please. Sorry, $4,800. Okay, last but not least, Christine talked about this a little bit, touched on it. I'm going to give you a solid example of leaving the IRA to charity and why that's beneficial. I love this quote from Warren Buffett. The perfect amount to leave children is enough money so that they would feel they could do anything, but not so much that they could do nothing. Isn't that a great philosophy? One of the richest men in the world, I think his kids each get 5 or 10 million. The guy's worth like 40 billion. Enough to do anything, not enough to do nothing. Next slide. So Christine talked about this a little bit. Before December 2019, if you inherited an IRA, the spouse who inherited could stretch the IRA distributions out over her life expectancy. So she didn't have to distribute the IRA in 1 year. She had her whole life expectancy to distribute out. Children could stretch the distributions over their life expectancy. So if I inherited an IRA from my father, I'm 54, I could stretch that out over 30 or 40 years. The other rules were a little bit more complicated, but the results were generally somewhere that kind of similar. Trusts could be specially written to stretch those distributions out over life expectancy. Why is that important? Well, let's say my father left me a $2 million IRA. I could stretch $2 million out over long enough that it could continue to grow, and the annual minimum distributions wouldn't really impact my tax return. Next slide, please. But the Secure Act, passed in December 2019, changed that. The spouse can still, the husband or wife who inherits an IRA can still stretch it over his or her life expectancy, but most others can't. Children, just about everybody else is limited to 10 years. Well, now let's say I inherited that $2 million IRA. Now I'm adding $200,000 a year to my tax return. I'm going to feel that. That's going to bump me into a higher tax bracket. I'm going to pay a lot more taxes on that much shorter distribution. And that's why Congress did it, frankly, was to raise money. Okay. Next slide, please. The net of this, and I'll show you an example in a second, IRAs are much more attractive as charitable gifts. They've always been attractive, but because an IRA is all ordinary income, the highest tax income, the highest tax rate, other assets like a home, real estate, securities like stocks and bonds, things like that, they pass through the trust, they get what's called a step up in basis at death. So that means that, remember that Qualcomm example, that cost basis of $5,000, that goes away. And the cost basis for an heir, somebody who inherited that Qualcomm stock, would be the market value today, or about $260,000. So there's almost no tax if the heirs sell the assets they inherit through the trust. But the IRA is all taxable income. I'll show you how this works. Next slide, please. So let's say a family wanted to be very generous to KPBS. They want to leave KPBS $500,000. They got a house in California. They got stocks and bonds worth about $600,000. Their trust assets are about $1.5 million. And outside of the trust, there's a $2 million IRA. They want to leave $500,000 to KPBS and leave the rest for the kids. Next slide, please. A little complicated here, but again, same gift to KPBS. On the left side of this table, we're going to give that gift to KPBS out of the house and the securities, out of the trust. So the kids get $1 million out of the trust. They get $2 million out of the IRA, but they have to pay 30% taxes on that because of the very high short distribution period. So the total to the kids is about 2.4 million. That's great. It's 2.4 million they didn't have last year. I mean, they'd rather have mom and dad around, but they get 2.4 million. On the right, what we do is we give to KPBS from the IRA. The kids get the full value of the trust, the house and the stocks at $1.5 million. They get $1.5 million of the IRA, but that's reduced by taxes, so it's $1.05 million. But you'll look at the total to the heirs. By giving money out of the IRA, there's actually $150,000 more available for the kids than if those gifts were funded from the trust. That's the thing, that's the power that makes planning so important. It's efficiency. Again, the same gift to KPBS, we're giving $500,000 to KPBS in both of these situations. But using one technique, the kids end up with more. There's more money left over for everybody, except for the IRS. Okay, next slide, please. So that's really what financial planning is. It's about making the most of your resources, whether it's $30,000 or $3 million. And the idea behind these strategies used annually and giving the IRA at the end is to help you keep more of the money you've earned over time, all while providing the exact same benefit to the charities that you support, like KPBS. And with that, we'll take questions.
Thank you, Rick. Appreciate it. A few questions coming through. One just came through around our SEPs treated the same way as IRAs regarding the gifting and inheritances. Excuse me.
Yep. SEP IRAs, simple IRAs, traditional IRAs are all kind of treated the same way. When we're talking about qualified charitable distributions, you can't do it out of a 401k or a 403b or a pension plan. You can only do it out of an IRA. But the SEP, the simple, et cetera, yes, you can do those. Or even better, roll it over into a rollover IRA and then you don't have to worry about it. Now, Roth IRAs, the inheritance rules are a little bit different with Roth IRAs. They're not taxable, so you don't get the same tax benefit for giving away Roth IRAs. In fact, you kind of want to keep those. Talking mostly about traditional IRAs or rollover IRAs.
Thank you for clarifying. We've gotten a lot of questions about just kind of the process around creating trusts and in general, and really like how much should folks be expecting it to cost them to get these things set up. Some folks had asked about, what does a fiduciary cost if you would prefer them to be the trustee or an executor. Can you talk a little bit about what people might expect through this process going to professionals?
Absolutely. So as to the professional trustee question and cost, a fiduciary or a corporate trustee will not charge fees until they are serving. So at the time of your incapacity or your death is when they would start charging their fees. It's often a percentage of the estate based on the value of the assets that they'd be managing. Sometimes around 1 or 1.5%, and then higher depending on what the assets are. Some local fiduciaries charge an hourly fee. They will all share their fee schedule with you when you are considering naming them, and that's one of the first questions I suggest asking them. It just helps project the costs of the trust administration phase. And then as to the estate planning costs, I personally charge my hourly rate if I am reviewing or revising an existing plan, because typically the whole plan does not need to be reinvented. And then when establishing a new plan, I usually charge a flat fee. That really does vary based on if I'm planning for a single individual, a couple, an estate perhaps with perhaps a home and a few accounts, or perhaps a very large taxable estate where we need to implement some of these other measures that we've been discussing. So what I usually do is arrange for a courtesy consultation, and during that consultation, I'm able to provide a quote. And I do think that's about the standard that you would find with any attorney that you would contact.
Thank you. We've had a lot of questions about trusts. People seem to be very curious about these various vehicles. A couple questions that keep coming up are, one, if you have property outside of the U.S., do you have to have a specialized trust, or do you have to have multiple trusts to handle that? And then also, if you maybe have dual citizenship, is there an advantage of where that trust is set up under which jurisdiction?
So a lot of it is based on where your assets are owned. If you have assets here and you have assets out of the country, you do need planning established in each country. Your trust here in the US, here in California, can hold any of your US-based assets. Assets outside of the country do require their own planning. For example, I have many clients with assets in Mexico. Mexico's will-based planning, and you would establish that will in Mexico and then have your living trust here in California. And then as to the citizenship question, that can get a little more complicated. It depends on tax matters as well. But ultimately, I would probably have the same advice that you would be looking at a plan in each country of citizenship if you had assets in each country. But certainly you can have your trust established in the U.S.
Another trust question. So by putting assets into a trust, does that protect them from liability matters, personal liability, or in terms of a business? And then also, how challenging is it to liquidate assets once they're put into a trust?
Okay, those are
If
both
you were
great
to
questions.
sell a real property or something of that nature.
Yeah, absolutely. As to the creditor protection, your ordinary family living trust does not provide creditor protection. Very important to know that. It's more of a succession planning and probate avoidance tool. There are some types of irrevocable trusts that could provide creditor protection, but the ordinary trust does not. However, you can build in creditor protection for your beneficiaries if you have concerns, for example, about a judgment of that a child is facing, a child going through a divorce, substance abuse, anything like that that might sort of subject them to losing their inheritance. You can include spendthrift planning to protect the beneficiaries. But your own trust does not provide that if it's the living trust that I've been referring to. And then as to, I apologize, Jared, what was the second question we were going to cover?
As far as maybe liquidating or selling real property once it's in a trust, is that similar to if it wasn't, or are there any limitations around that, or any challenges that people should be aware of?
Great question. It does not limit you from buying or selling assets. Think of it as you're operating your portfolio just as you do right now. Just have your trust or your trust certification handy when you're either going through escrow or meeting with your financial advisor, because that is the document that shows them certain provisions that your trust should have, called trustees' powers. And within those powers, it says that you, as the existing trustee, the existing person handling your assets, you have full control and power to do so, including the power to buy and sell.
And if there is a mortgage or a lien on those properties, that doesn't prohibit them from being placed in that trust. Is that correct?
Absolutely not. If you have a mortgage, put your property in trust. It does not prohibit you from placing it in trust.
Thank you. We've been getting more questions around trusts. I think a lot of questions around do you need to retain a lawyer to do this, or are there other resources that people can do this on their own? And what kind of costs in general for setting up this type of trust, a range should people be expecting to pay?
Christine, you mind if I tackle this one?
That would be great. Thank you.
And the reason
Thanks,
so Christine's a lawyer. She's got a dog in this hunt, right? She's going to say a lawyer should do it. I'm not a lawyer. I've read a lot of estate plans. Some of them are written by non-lawyers. And I'm here to tell you, a lawyer should do it. I mean, you can do a trust on Nolo for about $100. And Christine will tell you it's a train wreck when it finally gets acted on. You really should have a professional do this stuff. It's not DIY law is not a place for DIY, right? And I mean, the cost will run you. I've seen the quotes run the gamut. It really depends on the complexity of the situation. I've seen it as low as $3,000 for a relatively simple, straightforward trust, will, powers of attorney. And I've seen 5 figures when it gets really complicated. If you've got a lot of different entities, businesses, assets in different states, the more complicated it is, the more you're going to spend for good advice.
Thank you. We've been getting some questions around Prop 19 as well. I know that you touched on that. People are wondering, is it too late? And what other considerations do folks need to be considering between now and the implementation to determine if these are steps that need to be taken?
Okay, absolutely. It is not too late, but there is a lot of consideration that should go into whether or not you consider transferring a property right now. Again, February 16th is when Prop 19 goes into effect. I work on a lot of trust administrations, meaning I have a lot of clients or clients with family members who have passed away. In those scenarios, the date of death is the what's considered the transfer date. My deceased clients prior to that date do qualify for this. Now, if you're considering giving a property to somebody to take advantage of this right now during life, I encourage you to talk to your accountant, probably first and foremost, because you will need to consider capital gains. While you would most likely qualify for the property tax exclusion, therefore maintaining, your parents' property tax basis, you are also inheriting the basis at which they acquired the property. Meaning, let's say they bought it for, $100,000 here in San Diego many, many years ago, which we know no properties are worth that anymore. You will not be getting it at a stepped up basis right now during their life. You are inheriting it at that $100,000 I just gave an example of. So you could have some significant capital gains concerns. So it is a cost benefit analysis. Please do it immediately so that if you decide the property taxes are the benefit there, then you want to get that in.
Thank you. Maybe this is a question that Rick can answer. It was very specific, but we have someone who has they both brought children from previous marriages into the relationship, and they're wondering if there are vehicles within that trust to make sure that when they pass, their respective children benefit, if that makes sense.
One of the advantages of trusts is that you can be very creative in the trust. You can put a lot of provisions in to say, this kid inherits this kid inherits that, split it this way, twist it, you can tie it up in knots if you want to. That's one of the advantages for trust, particularly for mixed second marriages like this. The thing you don't want to forget to do is to coordinate your IRA and 401k beneficiaries with the trusts. You don't want to have, say, for example, your 401k going to your ex-spouse because you forgot to change the name. And you can change, set, your 401k goes to your kids, his 401k goes to his kids, etc. But that kind of coordination is very important, specifically, especially for blended families. And best to be done by a professional like Christine.
Wonderful. Thank you so much. So that is all the time we have now for questions. I do encourage you to reach out to Christine or Rick if your questions weren't specifically answered today. I believe you can find their contact information in the chat, as well as that will be provided in our follow-up email. There was just a tremendous amount of great information shared today, and we want to thank both Christine and Rick for taking time to explain some of these complicated and often nuanced vehicles with us, but hopefully people found some value in the presentation and can start on their journey and hopefully to a sound estate plan moving forward. We would like to thank everyone who attended today, taking the time. We know we all have busy lives, and it means a lot that you trust KPBS to provide you with these opportunities. We also want to be your partner when it comes to estate planning and charitable giving. So please don't hesitate to reach out to us with questions. We're here to help. We have an advisory board made up of estate planning professionals that both Rick and Christine participate in. But we can also then point you to folks who may have answers to your questions. One question that did come up was if we have lists of folks, estate planners that that maybe speak other languages, not English as their native language. And I'm sure that members of our board can put folks in touch with the appropriate person. We also have a wonderful program called our Friends for Life that KPBS utilizes to recognize those who choose to support KPBS through plan giving. We have annual events, communications, and unique recognition throughout our buildings. So there'll be more information on that on our plan giving website. We also have, if you didn't know, KPBS just turned 60 this last fall. And as part of that 60th year celebration, we put out a challenge to folks called our 60 for 60 Bequest Challenge. That's where if you can notify us that you have included KPBS in your will or estate planning, we can then document that and celebrate you with some special things around this campaign. There'll be some more information of that as well. But if you have questions or would like to know more about making KPBS a part of your estate planning, please reach out to us. You can email us at plannedgiving@kpbs.org. Once again, all this information will be in a follow-up email. And if you ever have questions, feel free to contact me directly as well. Once again, Jared Blakely, and that's jblakely@kpbs.org. So once again, from all of us at KPBS, thank you for spending some time with us. We hope that you got a lot out of it, and we will be following up with further information. And with that, I want to wish everyone a good night.